Chapter 52 Cruelty to Animals Section 700 A statutory offence. At common law animals, as such, had no right to protection from abuse or brutal treatment by man. One who mistreated an animal in such a manner as to impair its property value to its owner, might be liable to an action of trespass. Under some authorities, one who maltreated an animal because of malice toward its owner is liable at common law for malicious mischief. Other authorities hold the contrary, while statutes in many states make malicious mischief perpetrated on animals a crime, in which case the malicious intent must exist toward the owner, and not toward the animal. At the present time in most American states and in England, there are statutes which render it a criminal offense to cruelly and wantonly beat, wound, mutilate, or kill an animal. Other statutes punish cruel driving or overloading animals, or unnecessary cruelty in not providing food and water. These are crimes without regard to the ownership of the animal, and may be committed by the one who owns it. An acquittal of killing an animal with malice toward its owner does not bar prosecution for cruelly killing it. There are two theories advanced by the courts as the basis for these laws. One, that the offences are punishable under the police powers to prevent corruption of public morals by cruelty to living creatures. 8. The other, that animals have rights like human beings subject to protection. Some of the statutes apply to all animals, others specify domestic animals, cattle, or the like. A mule is held to be a domestic animal, a horse to be included among cattle, but a tame buffalo is not among cattle. A dog is a dumb animal, and pet birds raised in captivity are included among domestic animals. Section 701 Malice or intent is essential to offence. Malice toward the owner of the animal is not an element of the offence. It seems to be sufficient if the provisions of the statute were violated and the accused was actually guilty of a cruel or forbidden act toward an animal, even though he did not intend to mistreat it. Where the charge was knowingly and intentionally overdriving a horse, no specific intent to injure the animal was necessary. It was enough that the driver acted in wanton disregard of its suffering. It may be a defense that the animal was killed or wounded to prevent injury to one's property by it, if no other means of protection were available. Punishing an animal for discipline, done in good faith with proper motives, may also be a defense. Section 702 What acts indictable? It is said that any unjustifiable, willful or needless killing, even if done without torture, when the slayer was angry, is punishable under the statutes. Loosing a fox to be hunted with dogs, cock fighting, dog fighting. Docking a horse's tail, 26 Shooting at live pigeons during a shooting match as a test of skill in marksmanship, have been held punishable. Other courts hold the shooting at live pigeons not a crime. Under a federal statute it is a crime for an interstate carrier to confine animals in transit between states for more than 28 hours without unloading for food, rest and water.